Hi, I'm Don.
And I'm Lori. And we're
Talkin Divorce.
Welcome to Talkin Divorce with Don and Lori, where we bring together the experts who help you move from uncertainty to clarity through every stage of divorce. Today's topic is protecting what comes next, safeguarding your estate, updating legal documents, and rebuilding your financial foundation. Joining me are Alexandra Smyser, estate planning attorney at Schweitzer Law Partners, and Michael Harris, mortgage expert and president of United Mortgage Corporation of America. This conversation was so insightful that we've made it a two-part series. In part one, we'll focus on the legal and estate essentials, and in part two, we'll dive into the mortgage strategies, financials rebuilding, and how to build your post-divorce team. Let's get started. So excited to have our guests here, Allie and Michael. So today, what are we going to be discussing?
Well, Lori, this is going to be a very special program because most of our viewers have seen us talking about what happens at the beginning of a divorce.
Yes.
We talk a lot about some of the intricacies that people have to deal with while they're pending a divorce, but we're going to be talking about something that folks don't know about, and that's what happens afterwards. Is it really over with or not? And fortunately, we've got two great guests with us today. They're going to help us with these very important considerations that people should know now, not when they get to the end, but now. And of course, we have Michael and Allie who's going to help us.
Fabulous. So, so many people think, like what you said, once the divorce is finalized, that's it, and everything is over. But there's usually so much still that's left over to take care of. So, Dawn, let's start with that. I'd love to get your take on that.
Yeah, well, Lori, it's not over with until it's over with, right? Okay. So, yeah, at the end of a divorce, we have a judgment of dissolution, the marital status is dissolved, property is distributed, child custody orders are made, reimbursement claims. There's a lot that is finished, but it's really not finished because divorces, unlike other lawsuits, has a tail. And in that section, right after the divorce, there's things that need to be done, such as, let's say somebody's buying a house from the other side and they have to refinance that loan. Or, more importantly, they've got to think about their own demise, their death, and who they're going to distribute their properties to, when they're gone and stuff. And that's why we have these guests here today to help others figure out what they should be doing at that tail end.
And Allie, can you expand on that? Because you're with estate planning, and so there's a lot of different things happening at the end of a divorce, right? All moving parts. So I'd like to just start with your background and with what is that you do?
Oh, well, I'm an estate planning attorney. I'm the head of the whole estate planning department at Schweitzer Law Partners.
Fabulous.
And so I work a lot with our family law clients, either before the dissolution proceeding, in the middle of the dissolution proceeding, or after. In particular, after, we want to make sure that anything that the client is awarded in the dissolution, that we make sure to get it in their names, and then we talk about what kind of planning they need to have done, right? So if they've come off of a marriage where you've got a spouse who kind of stands first in line, a married couple, you've got some, even if they do nothing, at least if they stand for one another to act. But once you're divorced, you don't have that spouse. So we want to address what needs to happen at that point.
Yeah, Lori, one of the things that people should do is right at the beginning of the divorce, they should reference or meet with somebody like Allie. Talk about what their estate planning is, and if they don't have it, what they should have going into a divorce.
Okay, and emotional impact of realizing the loss, and what does it do? Like it remains? Does it go to the next phase? Like how do you help somebody transition into that? That's kind of a rough one.
That is a rough one.
So that's the process of the divorce attorney, right? A good divorce attorney is going to be talking to people about you going through a very stressful time, and your dreams are going to have to change, right? Your life as you knew it is over with, and your fear is probably a little bit more than it needs to be, but it's understandable, right? And so what we do is we try to give them a roadmap, people that you should meet with, things that you should be considering at the time of the divorce. And that includes, if you're going to, again, have to refinance a home, who are you going to meet with, and what are the details of that? Can you keep property and not change the mortgage? What are you going to do with your estate planning? Because if your ex-spouse is still in your estate planning, how's that going to look later on when you've got a remarriage or something like that?
And Michael, you you help divorcing clients through the mortgage process. So what happens on your end?
No, absolutely. Doing this 38 years, I've actually been there where I've done the loan when they got married, I've done the loan when they've had children, and I've done the loan when they got divorced. And doing that for 38 years and being part of that, and even on one divorce case, I was in the divorce papers. I can't talk to him, but I can only talk to her.
You were a bad guy to one of the spouses.
I don't know. I think he got the dog and I got her. But anyhow, you see the mistakes and you see the things that are done well with your experience. And as Don was saying, you've got to start early and think of these things, because usually the best solution is when both parties aren't happy. Because if one party's happy, the other job wasn't done well. So a lot of times it's looking at the overall, what is the estate? What is the items going on? Is there a business? Is there a value? Is what you would be doing on the valuation? Knowing if you need money from a home equity line of credit, depending upon if there's title issues or not. If you're refinancing to take someone off, did they qualify? Did one of the spouses mess up the credit? Understanding if we have to look at credit and look at helping that to gain the approval, to know if there's a possibility.
Michael, you're bringing up a really important point. Is a lot of people have visions of grandeur.
Yeah.
When you get a divorce, you're splitting the estate in half, right? And they may not be able to afford a new mortgage. And fortunately, you're there to say, yes or no. I mean, there might be some cases where you're never going to make it. Or you might be able to make it, but is that really in your interest?
Well, something I tell a client is, be careful what you wish for. I might make it happen. So it's like, I can do it, but do you really want that? Going into a little bit what I look at now, you got insurance, you got the new property taxes, you got all these things to consider, and it's not the lifestyle you had before. And then alimony, child support, depending upon where they are in the stage in their life.
Private school education.
There you go.
Yeah.
All these things matter, and you think, oh my gosh, this is great, until you go, oh gosh. And then I kind of tell people too, is just because you get the house, the door locks, the deadbolt goes, you're stuck. You want to be able to come and go. So you got to have it affordable.
One of the things also, I think that you probably talked to them about, that interest rate that you got 5 years ago, it's going to look different right now, and stuff. So
yeah, 2s aren't 3s and 4s and 5s, maybe 5s soon again, but still 6s. And all of a sudden your buying power is a little bit less, let alone if you had 2 incomes from the other party, all of a sudden it's one party. And then you got to look at all those consequences.
That interest rate impacts my planning too, because sometimes we can't get a client off, or we can't get, not a client, but we can't get another party off because the person who's receiving the property can't refinance or doesn't want to refinance at a higher rate. And so then we have to do some sort of creative planning around that to make sure that the ex-spouse is not inheriting.
Yeah, all of a sudden you have credit implications if one spouse is doing something to the other or getting back at somebody, depending on how amicable it is. And then you got to look at what is called interest rate versus interest volume. You're paying a lot of interest early, and then that has already happened. So sometimes rate doesn't matter until it does for debt to income ratio and qualifying. And all these things are important, and it's getting the ball in the early innings and understanding what you got so the game plan could actually make sense.
So Michael, I've got a very specific question for you. Let's assume that the spouse that's getting the house doesn't want to change the mortgage because it's just too sweet. She's paying maybe $3,000 a month for a 10,000 square foot home, right? And she knows that if she refinances, there's no way. Is it possible to arrange something for her to assume the loan or do something to that effect?
Well, any assumption's got to show the qualification to be able to handle the debt. So any new settlement that would be in order would show that there's proper support to cause that to occur. Without that, then it won't. Not that, oh gee, you do something to change something, but it's almost we need that income to get that assumption done, and then what happens after as long as it wasn't premeditated. It's understanding that possibility. Otherwise, I mean, I just had a loan where they did an equity line, pulled out money, paid the spouse, and the spouse, who was not a veteran, who was not on title, is now assuming his VA first. But the thing is, we were able to get her to qualify based on the support and alimony and lasting at least 3 years, and we were able to get that done with the VA assumption.
We're going to have him in on for a couple of hours here. Because every time you
So
speak,
many things.
there's more questions that come
Yeah.
up.
Yeah, his head's going, oh my God, I got more.
Me too.
But yeah, no, Allie, I would just love to know, like, estate planning, the process, and the paperwork that usually goes along with estate planning. Like, are there different forms, or is it just, it's a case by case basis? Like, it's really, like, if there's children involved, I mean, there's just so much that you can, do to help somebody move on.
Yes.
From their partnership.
Absolutely. So pretty much everybody over the age of 18 needs 3 probably simple things: a will, a power of attorney, and advanced healthcare directive, right? So that's what I recommend, just as our basis. Every single person should have that. Now, as you you are more mature and you have more assets and you maybe have children, minor children, children with special needs, maybe other family members that you take care of, then we start to get a little more complicated, right? Then we start talking about definitely a trust, what's called a revocable living trust, but basically a legal vehicle that owns the person's property and that avoids probate. And then that allows people to inherit without going through probate, and then we can make provisions for minors to inherit, to protect it, right? Protect it when they're minors, and then also, when they're 18, 19, 20 years old, that they're not getting big chunks of money. So those are kind of your basic, the advanced healthcare directive, the will, the power of attorney, then your revocable living trust. Then we can get more complicated from there, right? So then we can have special needs trusts and whatnot. But I think it's really important for everyone, to have the advanced healthcare directive and power of attorney.
Absolutely.
Yeah.
So can you break it down just really simply for our audience, why you need to get your estate planning changed at the conclusion of a divorce, in consideration of the fact that your ex-spouse might be on your current estate planning?
Pull the plug.
Yes. So, I mean, if I know it's not the topic here, but I think that we do need to touch upon that during the pendency of the divorce, you do need to do a power of attorney and an advanced healthcare directive, and most likely a will, because while the divorce is pending, that person is still your spouse. And while we have some people in our office that say, that's fine, he's still, he's the father of my children and he will do what's right, I would say the majority of people do not want their, estranged spouse to be making those decisions. So we start during the divorce. And then after the divorce, so any planning documents that you had before actually become void as by operation of law. But that doesn't really mean much, considering that if someone's walking around with the power of attorney saying that, I'm walking around with a power of attorney where Don has appointed me as his agent and I can walk into a bank, the bank doesn't know that I'm divorced, right? Or we're divorced. So it's important that at the, on the end, once you're divorced, you think about who you want, who you trust to make those financial decisions for you, your healthcare decisions for you, and that you're taking time to really think about if you're incapacitated and when you die, who you want to name to take care of things, because you don't have the fallback of a spouse, and you definitely don't probably want that ex-spouse to be making those decisions for you. And then just on the beneficiary designations, that's really important. I mean, that's where we see a lot of problems come up. So again, if you name a spouse as a beneficiary on, say, your 401k plan, and you don't change that after the divorce,
Then you still get it?
I mean, so it's void by operation of law. But again, the the institution that holds the retirement plan doesn't know that.
Right.
And so they will, if that named person shows up with your death certificate, which they very much will, that they'll distribute it to them. And then we end up with litigation on the other side. Let's hope they don't do that. But yes, it's really important. The beneficiary designations are a really important aspect that needs to be addressed at the end.
Yeah.
You know, once you're divorced.
Along with deeds, right?
Yes, yeah. So deeds are something we see, unfortunately, more than I like to see. So I think when you have the final, what is it called? The final judgment. You know, the final judgment says, okay, 123 Main Street goes to Lori, and that's great. You know, and that's signed by the judge, but the Los Angeles County Recorder that judge is not talking to the Los Angeles County Recorder, right?
Yes.
And so Lori needs to execute a deed. Well, both parties need to execute a deed to make
Transfer
sure.
title.
Yes,
Transfer
to transfer title.
Yeah,
So
because otherwise what's going to happen is that somebody dies and that property is held in joint tenancy, and by operation of law, on its face, it looks like the person's got 100% ownership, and that could cause a lot of litigation with family members and things of that nature. So that's why we get Allie involved right away to start transferring deeds as well as looking at the estate planning.
We had a situation just recently, and this is like an excellent example where the couple held title to she had separate property. She brought it into the marriage. It was definitely her separate property, but she had at one point transferred it into their joint trust, right? So husband and wife were on as trustees of the joint trust. The joint trust was, of course, revoked, but nothing was done immediately. And unfortunately, it was very contentious, and the husband had some mental health issues. And so to go back and try to get him to sign the deed, it was very problematic. Like we had to go back to court. He didn't want anything to do with it. He caused trouble the whole time, and it was just a matter of getting his signature on it, and so had it been done in the beginning
where
yes,
it should have been,
yes.
it would have caused less headache.
Exactly. And it put her in a bad position. She was done with that marriage. She didn't want anything to do with that man, but it put her in a bad position.
Well, you also had competency issues
Yeah.
for signing, and is it really correct or not?
Yeah, it's amazing how much carries over after the papers are signed. And that's where estate planning comes in. So the next step in protecting your future is obviously estate planning. And so what legal process is behind you? And then what comes the next question? Like once the legal is done and everything, what's the next step moving forward?
Well, the end of the divorce, per se, right? Because like we just talked about it.
It's a gift that keeps on giving.
Yeah.
That's right. We can call it an annuity, right?
Yeah.
But anyways, it's a judgment of dissolution. It's entered in the court, and then the world is on notice that you're a single person ready to get married again, Michael. So
I've been 31 years,
okay,
no divorce.
Okay, all right, all right. So that's what the dissolution of marriage is.
Yeah.
Okay, and it doesn't quite end in family court because of all of the complications that we've been talking about, and a lot more. I mean, there's also retirement accounts. Retirement accounts, if they are governed by ERISA, meaning the federal government, private plans, there has to be some special orders that go into effect. We call those qualified domestic relations orders. And they could be done during the divorce. Most frequently, though, they're done after the divorce. So what do we have? We've got a divorce attorney, but then we start bringing in other professionals that really come in at the tail end. I guess Michael, you're kind of like the goal kicker at a football game, right? You're there at the 20-yard line, just
What
ready to
is
close
it that you say that you like to do all the time? The quarterback?
Well, again, as I mentioned, it's having that team and it's protecting you against the quarterback. But we'll go for 2 today. No kick. Again, you alluded to that just right there, but it's really interesting because most of the time when you see you or others here, they're thinking about them. And a lot of times they're not thinking about the other. And they have their own playbook, but it's a shared playbook in order to get to the end goal.
Yeah,
That's
hopefully.
tough. Yeah,
Yeah.
and that's a tough thing to talk through, and
Yeah.
it's getting that audience.
What about if there's children involved in, the post-divorce? How does the children, how do they,
Boy,
they tie in?
you're just opening up a big
That's a
subject
big
here.
can of box.
So let me do the intro here, and then I'm going to hand it off to Allie. So
Okay.
obviously, there's a lot of our divorces. There's minor children, and that comes with custody orders and visitation orders, and a whole bunch of different rules as to how people are supposed to be sharing custody. And of course, after the divorce, they go back into court a lot, and they start disputing things and modifying orders and things like that. But there's also sometimes some very special cases where there's special needs kids, and that is a issue that definitely goes on forever for the rest of a parent's life. Post separation or post divorce, you not only have to pay child support, but if you have a special needs child, you could be paying child support for the rest of your life, because there's a thing that's called adult child support. Now, we're talking about special needs, we're talking about guardianships, conservatorships. There's a lot of things that are in Allie's world that's not in mine, and that's why there has to be a close cooperation between an estate planning attorney and a divorce attorney at the end of the case. Allie, can you talk a little bit about the situation where there's going to be a child that's going to turn 18 years old that's disabled,
Autism.
right? And the process that parents have to go through, and what does that look like?
So yes, for developmentally disabled adults, there is a special conservatorship. It's called a limited conservatorship, and what that does is the court looks at what the developmentally disabled young adult can do, what their capabilities are, and there's basically 7 aspects to it. So we can go to court and we can get a limited conservator appointed to make those decisions for the child. So that's like the court, and that's like where they live and who takes care of them and where they go to school and that kind of stuff. And then, of course, we can do a special needs trust for them within the parents' regular estate planning, so that when the parent passes away, the child can benefit from it, but the assets can be managed by someone else. And in particular, if you've got divorced parents, and this comes up, I mean, I think it's true that parents of special needs kids get divorced at a higher rate. I believe that to be the case, yeah. So many times we'll have divorced parents that are coming together to become limited conservators together. So they have to, I mean, they are tied together. And then each parent will have to do their own separate planning, of course, for the special needs trust.
And let's make this real clear: is none of this is dealt with in the judgment of dissolution. We're talking about the ship goes to a whole different court. It's the probate court with all different types of attorneys, unless, of course, the attorney handles both worlds, which would be crazy, I think. But yeah, it's really passing the baton at that point.
Yeah, but even for children that are not special needs, that are not developmentally disabled, we want to make sure that, especially for parents that are getting divorced, their kids are young or young-ish, now it's not, when you're married, and God forbid happens to one person in the couple, the survivor would inherit everything and kind of manage things for the kids until the survivor died. I mean, that's kind of, we do see that young parents do pass away. If you're a young parent and you're single, you want to make sure that you're doing what you need to do, which is your estate planning, to make sure you've got everything in the trust. You do not want to name your minor children as beneficiaries on your life insurance or retirement accounts or anything, because minor children cannot go to the bank and take, right? We have to do planning to protect minor children, so we want to make sure that now single parent has done their planning so that their minor children, and again, 18, 19, 20-year-old children are also being protected, you know? And then they might remarry too, you know? And so a lot of times, our clients at least, we do what I call a separate property trust for them. So whatever they've gotten in the divorce, you know, is protected for their children. And then down the line, if they remarry, they might want to do a joint trust with that new spouse, right? But what they've had, they want to go to their children, you know, and then when they're building their life, you know, after divorce and getting remarried, then we do other planning, you know. But this is just a really nice way to protect it for those children.
It just reminded me, sometimes that post-divorce thing is going to be called a prenuptial agreement for the next marriage, right? you know. So you like she's saying is, you know, you divorce and you got children, and the other side who you're going to marry has got children. At that point, it really makes sense to start thinking about not only a good estate planning, you know, but a premarital agreement, and you do those things side by side because they kind of complement each other.
Well, yeah, I figure it'd be balanced especially going into another relationship. You would want to have, you would think you would learn from your previous, you know, partner, right?
Yes.
So also with estate planning, let's say if a party is going to be inheriting like a bunch of property from like a relative or something like that. So that would that open up to another trust account, or would it just roll into, like, if you have a single parent, like what you were just talking about?
Yeah.
Can you put it into that trust account?
Absolutely, yes. So you can put and that's a great question, right? So if one party is inheriting property, yes, then it would go into that separate property trust. I mean, we do lots of things. We can get as creative as you sort of want to, but if people like simplicity, I like simplicity, to have it all in one separate property trust.
I like it protected from like my ex-spouse or from anybody trying to, you know, get dibs.
Yeah, definitely. And another thing is, you know, if you know, in my single parent scenario, also, you know, if this spouse, the ex-spouse, is inheriting and they want everything to go to their kids, they also want to sometimes protect, that comes up, they want to protect it from the children's parent, right? So I see it a lot where, you know, our client says, my kids are subject to undue influence from their other parent. And so I want to make sure what they inherit from me is protected. You know, there a lot of times I see concerns.
Yeah. And Michael, what do you see on the, like, with the house and the financing and stuff like that? What do you see?
I think it takes it out of the kids' side of it, but puts it right back in as to where the new parent, do they have an ability to house the child? Is the child going to be safe? What's the timelines that they're there? Are they there during school or not school times? Is it going to be carting here to there, the distance between them? One may not be able to afford to live where the other one's living anymore, and now distance becomes an issue. All these things happen, but on my end, or typically on a lending end, oh, what do you qualify for? Let's get the loan. Well, there's a lot more to it.
Can I stop you there?
Yeah.
Because these are the questions that, you know, that are coming up as you speak.
Yeah.
So a lot of our clients maybe haven't worked for many years, but they're collecting spousal support.
Right.
And they think that they could qualify for a loan by showing that they're receiving spousal support payments. How does that play into your decision and then the bank's decision as to whether or not this person is going to qualify?
Well, first thing, we need to see that the deposits are being made, that the spouse is actually receiving the money and not just it's on the order. So we have the order, of course, but then we want to see those deposits coming in. Generally, I'd love to see 6 months, but if it's just started, there are allowances to that. We also want to look at credit scores. So thus, they may not have their own credit. So now we're trying to go, what kind of financing? FHA financing, which is not only for first-time home buyers, or it's looking at bank statements if they're self-employed or opening a new business. Now, if they open a new business, that's another whole business altogether because they don't have a history yet of earning that income. We don't know what the taxes would show. So now there's loans that are bank statement loans, 1 month, 3 months, 6 months bank statements. But generally, they want to see 2 years of self-employment. Sometimes 1, but generally 2. But something you alluded to.
Well, let me ask you this before you get into that.
Yeah.
Is let's say that you're dealing with somebody that's got a large spousal support order.
Yeah.
$30,000 a month. She's married to a doctor, right, or divorced from a doctor. Does the amount of spousal support factor into your decision?
Well, sure. I mean, it's the debt to income ratio. Again, it's qualifying for the payment, the taxes, the insurance. The area that I mentioned, the loan that I just did, we did a home equity line of credit. She qualified for the assumption on that VA first, but with the support, both alimony and child support, that was the income we used to qualify, just happening, to qualify for that line of credit and the first lender to take on that assumption.
So child support is also considered.
Correct, because that money is coming in and not being drained from the other money in order to pay for that on the custody
Do you
side.
look at how old the kids are?
Well, of course, it has to last for at least 3 years.
Okay.
So it would go away, and in some cases they can extend, as we just mentioned, where it's actually where I've not gone through a divorce, but also
Poor
I'm aware.
guy.
Yeah, there you
know
go.
what you're missing.
Yeah, but I'm aware of my son's special needs. He's 26. My wife teaches with LA Unified School District. She teaches special needs preschool. So I'm around a lot of that on a regular basis. So I take probably more care than most when I see these circumstances because I understand it from a different perspective. And my daughter's finishing her master's in school psychology to be a school psychologist. So again, I get all those debates at home. So.
Divorce may close one chapter, but it opens up the door to an entirely new one. And the right planning makes all the difference. Thank you to Don, Allie, and Mike for sharing their expertise and insights. And if you think today's discussion resonated with you, then please subscribe to Talkin Divorce Pasadena on YouTube for more expert conversations that will help you move forward with clarity and confidence. And remember, you don't have to do this alone. There's always a way to protect what's next.